Well, there were a lot of conversations early on before we cast. Honestly, Sony, it was supposed to be a really small indie movie at Wayfair, and then Sony got involved later, snowballed from there. But we had a lot of conversations about aging the roles.
Blake Lively's legal blitz isn't slowing down. On July 3rd, she reportedly issued a wave of subpoenas targeting numerous individuals. Publicly, her team disclosed to TMZ that Candace Owens, Andy Sr., and Perez Hilton were among those named, and it's likely that information came from her attorneys or PR people. What they didn't share, however, is that her subpoenas also targeted smaller and independent creators. We were notified by YouTube last week that Blake's legal team is seeking our bank account records, which is absolutely absurd. We are vigorously objecting to it. And just yesterday, X, formerly Twitter, notified about 20 users that their information had also been subpoenaed by Lively's lawyers. What's shocking is that these weren't large creators, they were everyday users, including lawyers, journalists, and regular people who had simply discussed the case online. Many aren't even monetized creators. Some are just users who share their opinions. Yet, Blake is demanding their personal data. This raises serious questions about how far she's willing to go. If she's subpoenaing YouTube and X, is TikTok or Instagram next? Maybe even Reddit? Her actions suggest she'll stop at nothing to prove a conspiracy that simply doesn't exist. Ironic, considering she's labeled her critics as conspiracy theorists. One user on X, known as the Spiritual Shift, who appears to be an attorney, publicly revealed receiving one of these subpoenas. Here's what they shared. I was just subpoenaed over my X posts on the Blake versus Justin case. Like many of you, I've only discussed publicly available information. I'm a licensed attorney and small content creator, not monetized. No ads, no sponsors. Just a few thousand followers. I started covering the case because it mattered and exposed how celebrity power and PR manipulation control public narratives. They explained how they were skeptical of Blake's claims in the beginning, noting red flags in her filings that seemed exaggerated or distorted. Their posts reached over 38 million views before the subpoena arrived, demanding access to their private account details for simply expressing an opinion. The subpoena email from X read, "We're writing to inform you that X received the attached legal process dated July 3rd. No account information has been disclosed yet. However, X may be required to provide basic subscriber information in the future. If you wish to challenge this, please contact the court or requesting party directly." The email also included links to organizations like the ACLU and Electronic Frontier Foundation, which protect free speech and privacy rights online. Some have suggested reaching out to these groups, though they're often selective about the cases they take on. Still, this situation is clearly becoming a free speech issue, not just a lawsuit. It's unbelievable that Blake's team is targeting X users, most of whom make no money from their posts. They're simply talking about public matters involving public figures. This feels less like a lawsuit and more like an attempt to intimidate and silence critics. Even the most litigious celebrities rarely go to such extremes. This level of obsession suggests something deeper, perhaps driven by insecurity or control issues. It's unclear whether it's more Blake or Ryan Reynolds pushing this, but it's concerning either way. Meanwhile, in court, Judge Lyman recently ruled on Wayfair's motion to compel Lively's financial and business records. Wayfair sought evidence to support or refute her claims that the alleged smear campaign damaged her businesses. Blake resisted, saying her finances were too complex and that her net worth was irrelevant. The judge partially agreed. He ruled that while her net worth doesn't need to be disclosed, she must provide business and income records to substantiate her claims of financial loss. If she's alleging that her product sales dropped 56 to 78% because of Wayfair, she must produce proof. But here's the problem: proving those losses were caused by a smear campaign. Rebuilding Blake Lively's reputation at this point and try and convince people that her actions are rooted in fairness rather than frustration will be incredibly difficult. What started as a strategic legal push has rapidly turned into something that feels like damage control. With her legal case weakening by the day, her former attorney Jed Wallace abruptly exiting the team, and a growing number of independent creators now questioning her motives, Blake appears to be scrambling to hold together a narrative that's slowly falling apart. Inside legal circles, there's a quiet but growing consensus that Lively's approach has backfired. What might have once seemed like a controlled legal offensive designed to silence critics or reframe public reception now looks like an overreach that has generated even more negative attention. Instead of protecting her reputation, the aggressive legal tactics have amplified scrutiny and drawn new voices into the conversation. Observers point out that the decision to target online creators, commentators, and small channels was a particularly risky move. These creators thrive in digital spaces built around transparency, receipts, and open source discussion. Trying to intimidate or silence them often produces the opposite effect, rallying audiences behind them and giving the story more oxygen. For someone like Blake, whose brand has always depended on relatability and public goodwill, the optics couldn't be worse. Behind the scenes, sources familiar with the case describe mounting tension among her advisors. Jed Wallace's departure reportedly came after disagreements over how far the legal team should go in pursuing subpoenas against digital creators. One insider suggested that Wallace had cautioned Blake about the long-term reputational risk, emphasizing that while she might win small procedural victories in court, she was losing the larger public narrative. When Wallace left, it sent a signal to many that even within her own camp, confidence in the strategy was fading. With a new legal team now in place and a more aggressive tone emerging from recent filings, Lively's focus seems to have shifted from defense to retaliation. She appears determined to regain control by challenging what she sees as coordinated defamation from online commentators. Yet, in doing so, she's invited fresh rounds of analysis and speculation from legal YouTubers, entertainment journalists, and even attorneys who are now dissecting her every move in real time. This feedback loop is what makes the situation so volatile. Every new filing, every court motion, and every rumored settlement becomes another headline, another TikTok breakdown, another trending Reddit thread. And while her lawyers may insist that she's fighting misinformation, the perception outside the courtroom is very different. To much of the public, it looks like a powerful celebrity attempting to suppress free speech and criticism under the guise of legal procedure. As for whether content creators could sue her back, the answer is complicated and heavily rooted in legal precedent. Because most of her statements and allegations are being made within the context of a lawsuit, they fall under what's known as litigation privilege. This is a powerful protection under U.S. law that shields parties and their attorneys from defamation claims based on statements made in legal filings, hearings, or official court documents. In other words, even if something written in those filings turns out to be false or misleading, it generally can't be used as the basis for a defamation suit. That doesn't mean she's immune from consequences altogether, but it does mean the path to accountability is narrow and expensive. There's a potential legal remedy under Federal Rule 45, which governs subpoenas and discovery requests. If a court determines that a subpoena imposes an undue burden or expense on the recipient, for example, demanding private data, financial records, or personal communications from small creators, it can impose sanctions or even force the issuing party to pay fees. But that's rare. Judges are often reluctant to award costs unless there's clear evidence of bad faith or abuse of process. For most creators, the practical barrier is financial. Defending against even one subpoena can cost thousands of dollars in attorney fees, especially in federal court, where procedural requirements are complex. Challenging multiple subpoenas or filing motions for sanctions could easily climb into five-figure territory, a price far beyond what most small channels or independent journalists can afford. That's why, right now, the strategy among those targeted isn't to fight fire with fire, but to coordinate and protect. Several attorneys representing smaller creators have begun sharing resources, drafting joint motions, and aligning arguments to push back against what they see as overbroad or invasive demands. Their immediate goal is to safeguard privacy and set a precedent that discourages similar actions in the future. Suing back, at least for now, isn't on the table not because they lack grounds, but because the cost-benefit ratio simply doesn't make sense. Still, there's a growing sense of solidarity among the creator community. Each new legal maneuver from Blake's camp seems to draw more public support for those being targeted. Hashtags like #CreatorsUnderFire and #FairUseDefense have trended on X and YouTube, amplifying the broader discussion about celebrity power, online speech, and the fine line between protecting one's image and suppressing criticism. Legal experts have noted that even if Blake eventually prevails in certain motions, the reputational damage may already be irreversible. Core victories don't always translate into public vindication, especially in an era where perception often outweighs precedent. The digital audience isn't waiting for a judge's ruling. It's reacting in real time, forming conclusions as documents leak, analyses circulate, and videos go viral. Ultimately, the irony is painful. In trying to regain control of her story, Blake Lively may have ensured she loses control entirely. What began as a carefully managed legal response to a few critical voices has spiraled into a full-blown public relations crisis. Unless her team recalibrates, shifts tone, and begins rebuilding trust rather than enforcing silence, this chapter could mark a permanent turning point, one from which even a polished Hollywood comeback might not be enough to recover.